A case digest of the case of Republic vs. Lamaclamac, GR number 240331, March 16, 2022. The Republic sought cancellation of Decree No. 756523 claiming laches, but courts ruled the decree final, vesting ownership in Lamaclamac. SC upheld CA, affirming ministerial duty of LRA to issue title. The facts of the case. The Republic of the Philippines, represented by the Department of Transportation (DOTR), filed a complaint to cancel a decree against Guillermo Lamaclamac and the Land Registration Authority (LRA) regarding a 9,386 square meter parcel of land in Alubijid, Misamis Oriental. The land, identified as Lot No. 12446, was awarded to Lamaclamac by Decree No. 756523 on August 26, 1941. After Lamaclamac's death in 1947, her heirs sold the land to the government, which now uses it for the Laguindingan Airport Development Project. The DOTR argued that Lamaclamac abandoned her rights by not securing a certificate of title, but the RDC dismissed the complaint due to insufficient evidence. The Court of Appeals affirmed this decision, and the Republic's petition for review was filed to challenge the CA's ruling. The issues of the case. Point 1. Whether there was sufficient evidence to establish that Decree No. 756523 was transcribed in the registration books of the Register of Deeds. Point 2. Whether the absence of such transcription implies that the original certificate of title was never issued. Point 3. Whether the failure of Lamaclamac to secure a certificate of title after more than 65 years amounts to an abandonment of her rights. Point 4. Whether the principle of laches applies in the context of land registration cases. Point 5. Whether the issuance of a decree in a cadastral proceeding, once final and executory, vests title of ownership regardless of subsequent administrative actions. Point 6. Whether the petitioner's contention that title had not been finally adjudicated is legally tenable. Ruling. Dismissal of the petition, it was found to be bereft of merit. The court affirmed the CA decision and, by extension, the RDC ruling dismissing the complaint for cancellation of the decree. The court held that once a decree is issued by the cadastral court and attains finality, it vests title of ownership in the adjudicatee. The remedial issuance of the certificate of title by the LRA is a ministerial duty and does not affect the ownership once the decree is final. The absence of the certificate of title or its transcription in the Register of Deeds does not establish a lack of final adjudication. The court rejected the contention that Lamaclamac abandoned her rights by failing to secure the title. It was held that neither laches nor the statute of limitations applies to decisions in land registration cases. Doctrine. Title to land amidst cadastral proceedings is vested upon the adjudicatee when the decision of the court becomes final, irrespective of subsequent administrative transcriptions. The decree issued by the judicial authority is the decisive act that settles title, and its finality renders any subsequent administrative omissions inconsequential. The issuance of the corresponding certificate of title by the Land Registration Authority is deemed a ministerial act that follows automatically once a cadastral decision has been finalized. The adjudicatee is not required to pursue further administrative actions to validate the adjudication of title. The doctrines of laches and prescription do not apply to land registration cases because such cases serve to declare and confirm ownership by judicial fiat. The Sta. Ana doctrine and its progeny underscore that additional delay or inaction following the final adjudication does not diminish the legal rights conferred by the decree. This principle upholds the fundamental objective of the Torrens system, that of ensuring indefeasible and conclusively settled property titles. Thanks for watching.